Okay, well, good afternoon. Welcome to the Honors College. On behalf of the college and the Lyceum Initiative, let me thank you all for being here. Let me also begin by thanking our generous sponsors who have helped to make this event possible with grants. The Elizabeth D. Rockwell Center for Ethics and Leadership, which is directed by Dr. Brandon Williams and has its home in the Hobby School of Public Affairs here at UH. And also the Jack Miller Center, a private nonprofit that is committed to supporting the teaching of America's founding principles and history. The Lyceum Initiative in the Honors College is dedicated to a renewal of civic education here at the University of Houston. Next year, we will celebrate the centennial of the university. Our origins in 1927 as a teachers' college, founded by the Houston Independent School District, were transformed soon after, in 1934, by the formal charter of the University of Houston, with its own Board of Regents. The mission statement inscribed in that charter dedicated the university to providing excellent higher public education for working-class citizens of Houston and Texas. In that charter, it says, quote, "The continuance of a democracy depends upon an organized public educational program which must become a continuous lifelong educational process. Such an educational program is needed to provide a background for intelligent citizenship. The education of our citizens," it says, "to meet the issues of life must develop the qualities of open-mindedness and a willingness to work together for the common welfare." So our original charter thus laid out the foundational responsibilities of the new university, shared with the citizens of the community, namely to provide higher education that serves the public welfare, cultivates a better understanding of our political inheritance, and promotes open-minded inquiry and civic discourse, thereby preparing students for engaged citizenship and intelligent leadership. The Lyceum Initiative revives this fundamental commitment of the university's academic mission, striving to prepare our students for thoughtful citizenship in a constitutional republic by fostering the virtues of mind and of heart that sustain a free people. Our purpose is civic and patriotic, but not partisan. In pursuit of this civic mission, through the Lyceum Initiative, the Honors College joins a national movement in higher education that is dedicated to reclaiming civic learning and civic virtue as vital facets of a liberal education and of American citizenship. Knowledge of and reflection upon the fundamental principles of our constitutional order establish the enduring foundation for reasonable civic discourse, civic engagement, and civic leadership. We in Honors are committed to the formation of our students both as lifelong learners through liberal education and as engaged citizens through civic education. Now, Abraham Lincoln in his Lyceum address foresaw the need for such education in each generation of citizens. In his 1838 address, Lincoln gravely warned his fellow citizens of the dire threat posed to the nation by the political violence that accompanied a gradual erosion of respect for the rule of law and reverence for our constitutional order. The perpetuation of our political institutions, he argued, depended on civic learning, enlightened citizenship, and reflective patriotism in order for each generation to renew its devotion to constitutional self-government. In fulfilling our academic mission as a public institution of American higher education through the activities of the Lyceum Initiative, we meet the challenge of our own times. The Lyceum Initiative takes up the task of cultivating the knowledge of the fundamental principles of our republic and the virtues and duties of good citizenship in order to preserve and perpetuate our constitutional order. As part of the Lyceum Initiative, we inaugurated a host of students who we have called the Lyceum Fellows, many of whom are here, and they represent our first cohort of honor students whose academic work and research projects are dedicated to the study of our founding documents. This inaugural lecture series aims to extend the mission of the Lyceum Initiative more broadly among all honor students. This series opened with the 2025 Constitution Day lecture by Dr. Paul Carisse, who spoke about the essential need, especially in our times, to cultivate knowledge and virtue among citizens through civic education. The first three lectures of the spring by Dr. Doug Irwing, by Dr. Scott Kreider, and Dr. Lisa Vetter focused our attention more directly upon the Declaration of Independence itself, the founding document of our nation, especially in this year, the celebration of the semi-quincentennial, or 250th anniversary of America. Now, all of those lectures are accessible online through the Lyceum Initiative webpage if you were unable to attend. But let me now introduce Dr. John Dinan, who will deliver the fourth lecture in this series. Dr. Dinan is Professor and Chair of Politics and International Affairs at Wake Forest University. His research focuses on state constitutions and federalism. He served as editor of Publius, the Journal of Federalism, and as the chair of the Federalism and Intergovernmental Relations section of the American Political Science Association. Dr. Dinan is the author of several definitive books on state constitutions, including State Constitutional Politics, Governing by Amendment in the American States, Keeping the People's Liberties, Legislators, Citizens, and Judges as Guardians of Rights, and this one, The American State Constitutional Tradition. He's also published numerous scholarly articles and book chapters on state constitutionalism, including the fascinating history and development of a distinctly Jeffersonian tradition of variation and experimentation within the constitutional conventions and the constitutional amendments in each of the United States. Because his is the authoritative voice on the first American states, we invited him to address this particular phrase in the Declaration of Independence, that to secure our rights, governments are instituted among men. And we asked him to talk about this phrase in order to help us better understand state constitutionalism and the early American Republic. Please welcome Dr. Dinan.
Thank you very much. Thank you very much for that. It's a real pleasure to be here at University of Houston to be discussing the Declaration of Independence in the context of state constitutions. It's a particular honor to be here discussing this topic because I know that for many years, Professor Donald Lutz, one of the preeminent scholars of state constitutionalism, taught at University of Houston. Professor Lutz inspired so many of us to study state constitutions. He always inspired us to take a look at those texts, read those texts closely, state constitutions, other founding era documents. So it's a real pleasure to be here. So much of our attention is focused on the U.S. Constitution, understandably so. It's understandable that in this 250th anniversary of the Declaration of Independence, a lot of the focus will be on the Declaration as a precursor to the U.S. Constitution, to the U.S. Bill of Rights. That's all understandable. But looking at the Declaration also points us to state constitutions, also points us to the rich deliberation about governing institutions that took place in state constitutional drafting. Both beginning in 1776, continuing on until 1787, and then for many years thereafter. My purpose today is to focus on the American experience with state constitutions at three key moments. First of all, in the period before the drafting of the federal Constitution. Second, during the drafting of the federal Constitution. And third, in the years following. To preview my argument today, I will argue that state constitutions have been an exceptionally rich site of deliberation about and experimentation with constitutionalism. And that we don't fully appreciate today how many of the key questions about constitutionalism in the U.S. were first worked out in the state governments. And we don't appreciate to the full extent how much in drafting the federal Constitution, convention delegates drew on that experience of state constitutions. And we also don't fully appreciate, I would say, how much state innovation and experimentation has continued well after 1787. Let me start by considering the first state constitutions. We all, I think, have a sense of what we're supposed to be celebrating, the key date this 250th year. We understand it's all about July 4th. That's all leading up to July 4th because that's when the Declaration of Independence, we assume. But several other dates in 1776 are also very important, are also worthy of us taking note of. January 5th. So January 5th. That's the date that New Hampshire drafted the first state constitution in America. March 26th. Professor Gish reminded us of this last night helpfully when he said, we are, because yes it was March 26th, we are celebrating the second state constitution in America, South Carolina drafted the second Constitution, March 26, 1776. Or June 12th, when Virginia drafted the first Declaration of Rights in a state constitution. They actually did it in separate forms. They did a Declaration of Rights in June 12th, and then came back 2 weeks later. Came back 2 weeks later and drafted what they called a frame of government, and they put those together, and that made up the inaugural Virginia Constitution. And then finally, July 2nd, that's the date that New Jersey drafted the fourth state constitution. All of this took place before July 4th, 1776. And state constitution making continued at a rapid pace even after July 4th. Over the next 11 years, from 1776 to 1787, of the 13 original states, 11 of them drafted state constitutions. You say, who are these other two? Connecticut and Rhode Island kept their colonial charters until 1818 and 1842 respectively, so they were not. It's only 11 of the states that were participating in this initial bout of constitution making. And then I should also mention Vermont, which in 1777 drafted a constitution, came back a decade later, drafted a second state constitution, even though Vermont wouldn't join the Union until several years after it had taken place. In fact, I mentioned Vermont drafting and then redrafting during this time. South Carolina and New Hampshire also came back and drafted a second time. Those initial South Carolina and New Hampshire constitutions were really intended to be temporary constitutions. They said just while this war is going on. So they came back a few years later and said, okay, now we're going to pass more permanent constitutions. My point is, this is a particularly exciting period of state constitutional innovation, and the public officials were grappling with the whole concept of a constitution. After all, we need to place ourselves in their position. They didn't have much to draw on when they said, like, oh, we're drafting a constitution. In that sense, the constitutions really hadn't been framed in this sense before this was being done. And so Americans in the 1770s, they had to navigate their way through a lot of questions. Some of the questions I'll get into: who should frame a constitution? How do you approve a constitution? How should a constitution be updated? What do you put in a constitution? What contains that? And they're feeling their way through. My key point is this first decade is this kind of formative period. Let's take up the who. They had to figure out who should draft these constitutions. If we look at what some of the early constitutions were drafted, it was really drafted by legislators. They would be in legislative session, and then they would basically step aside and say, okay, now we're going to be constitution makers. And then they would step back into their legislative role. And people said, well, that's okay, that's one way to do it. But very quickly it came to be understood we should really have a separation of those tasks. We should have separate elections to elect delegates who would be tasked with drafting a constitution. That's separate from the job of electing legislators. This quickly took hold, and that you could call these, have special elections, select delegates to a convention, and they will be the ones to draft a state constitution. But then Americans also had to figure out who should approve a constitution once it was drafted. Initially, it wasn't thought, this might be surprising to us today, it wasn't thought that after the convention delegates finished up their work that they would have to submit it to the public for approval. You may say, well, why not? Well, the idea is in the elections to select the delegates would have been aware of public opinion. And then as they carried out their work, the delegates would have been conscious of public opinion. So it was thought, no need to then go back to the people again and say, do you approve of our work? Massachusetts was the first to pioneer the idea that the convention delegates would actually have to then submit their work to the public for approval. Interestingly enough, the first time Massachusetts did that, the people said, no, we don't grant our approval. You've not done the job that we wanted you to do. And so Massachusetts had to hold another convention. And they went back to work again, drafted another constitution, submitted to it, and this time this one was approved by the people. And this was the Massachusetts Constitution of 1780. I should take stock here. The Massachusetts Constitution of 1780 is still in effect today. It's been amended many times, but that is still the current Constitution. If anybody ever asks in a question, trivia question, history question, say, what's the longest enduring Constitution in the U.S.? The answer is not the U.S. Constitution. The answer would be the Massachusetts Constitution of 1780, which predates the U.S. Constitution by 7 years. And Massachusetts did pioneer this idea of requiring a constitution to be approved by the public. New Hampshire followed suit a few years later when they were crafting their revised 1784 Constitution. This didn't immediately take hold. Even for decades afterwards, some states would still say, actually, we don't need to consult the people. Eventually, though, it would take hold. No, the people should approve of constitutions. Then there's the question about how do you go about updating a constitution? Again, state constitution makers just didn't have much by way of examples to draw on here, so they had to do some experimentation. In fact, some initial state constitution makers didn't even provide for an updating process. They just said, here's the Constitution and that's it. Over time, though, some state constitution makers said, we've got to provide for an amendment process. Legislature can craft an amendment, goes to the people, and then it gets approved. And then some states said, what's one thing to provide for the legislature to have an option of having an amendment, we should also provide the legislature could call a constitutional convention and redo or take a look at our work. But then some state constitution makers said, but all this is in the hands of the legislature. They'd be the gatekeeper for all of this. We want to require a regular review. So in their initial Massachusetts Constitution, Massachusetts required in 1780, 15 years from now, the people should be faced with the question, do you want to call a convention to revise the Massachusetts Constitution? They want to provide that opportunity for people 15 years later to say, what do you think? Well, New Hampshire said, well, that's one thing to ask the people if they want to call a convention. New Hampshire says 7 years after this Constitution takes effect, a convention must be called. You must actually hold a convention to revise. And then Pennsylvania and Vermont had one of the more interesting ideas that I've seen. They had something called a council of censors. And this council of censors would come into being every 7 years. And their job was to take a look at the whole of government in those states and the whole of the constitutions and say, how well the things are working? Have we departed or deviated from our first principles? If so, let's call a constitutional convention and actually kind of take ourselves back to where we should be. My point is, these are all some really interesting innovations during the first decade of state constitution making, all driven by the idea that a constitution should be periodically looked at in that sense. Final thing that state constitution makers had to grapple with in this founding period is, what do you put in a state constitution? What kind of governing institutions should you craft? Let me just give a sample of some of the questions that came up and some of the range of answers. How many houses of the legislature shall there be? One house or two houses? Pennsylvania, Vermont, and Georgia said one house legislature sounds good. Other states said, no, two bicameral is the way to go. Or, how frequently should legislators be elected in this one house or two house legislature? Most states said, well, it's got to be annual elections every year. Rhode Island, though, said, no, it should be every 6 months. We want twice a year elections. On the other end of the spectrum, several states in their upper house said, no, you can have a 4-year term. And Maryland went so far as to say, you can have a 5-year term in that way. So these are some of the range of answers that they gave. Another question that came up, whether to impose term limits on public officials. Term limits on governors were somewhat common. About half of the initial state constitutions said, okay, the governor has to be rotated in office. But how about for state legislators? Those were less common, but the original Pennsylvania and Delaware Constitution both limited the number of terms that legislators could serve, therefore providing for rotation in office. And then a final question they had to face. Do we want to have a truly independent executive with any meaningful degree of power? A number of early states said, actually not really. The governor is going to be heavily dependent on the legislature. The legislature will select the governor. The governor will not have a veto power. It's a pretty weak office. But then New York comes in 1777 and says, actually, we want the people to elect the governor and therefore endow the governor with this independent source of power. And then Massachusetts took a very big step a few years later and say, we're going to allow the governor to veto legislation. So a range of answers. My point, just to sum up the first of my three main kind of sections of the discussion is, state constitution making in the founding era was characterized by a pretty remarkable degree of innovation and experimentation. Let me turn to my second main topic. What's going on in the Federal Convention in 1787? Well, you can already see my point here. When convention delegates gathered in 77, they were not writing on a blank slate. They were not just starting from scratch to think about constitutions. They could draw on over a decade of experience of crafting state constitutions. And in fact, I would argue that an unappreciated aspect of the Federal Convention of 1787 is the degree to which the delegates at this convention were constantly drawing on examples, insights, and lessons from state constitutions. And not just the convention itself in the convention debates, but if we look at the Federalist and Anti-Federalist papers that came up afterwards, they're constantly drawing on state constitutional experience. I would go so far as to argue that the success of the design of the federal Constitution owes a great deal to the fact that it was preceded by so much state constitutional experimentation that allowed an opportunity to improve and perfect our knowledge of constitutions and constitutional design. I guess one way to put things is to say, it's true James Madison, who we think of as kind of like the leading kind of figure of the Constitution, it's true he drew heavily on lessons from ancient and modern confederacies. He wrote a piece on that, he clearly did. It's true that all the founders, of course, any serious founder had read their Locke and their Montesquieu, so they'd read their theory. But I would say that nothing was more influential in the work of the convention or in the Federalist and Anti-Federalist papers than the experience with state constitutions. And this comes through in any reading of the convention debates or the Federalist papers. Now, what lessons were they taking? Some of the lessons I would say were positive lessons, where convention delegates take a look at the state experience and say, that sounds like it's something to be emulated. For instance, when it came time to decide how the proposed federal constitution would be approved, the convention delegates drew heavily on the Massachusetts model. Well, of course, you've got to submit it for ratification. And they did. They submitted a ratification, in this case, by states. Or, when it came time to establishing the executive branch, the federal convention delegates followed New York in making sure that the president was selected independently of the legislature. And they followed Massachusetts in giving the president a rather powerful veto. They were, in short, intent on creating an independent and powerful executive, at least powerful enough to protect the executive branch against predations from the legislature, in that sense, at least that much powerful. How about when it came time to deciding, more specifically, how the president would be selected and settling on an electoral college arrangement? The framers were very much aware of an electoral college arrangement of sorts in Maryland for choosing state senators in Maryland. People in Maryland did not directly choose their state senators. No, they voted for electors, and the electors would then gather and they would choose the senators for the state of Maryland. So these are some positive lessons that the convention delegates of 1787 could draw. But they aren't all positive. There were plenty of cautionary tales, negative tales. This is to be avoided. I mean, again, because learning takes place in here's what we want to emulate, here's what we want to avoid in that way. And where convention delegates in 1787 were very intent on going a different direction from some state constitutions. For instance, when designing Congress, the federal convention delegates were very clear they wanted to move far away from Rhode Island's idea of every 6-month elections. In fact, they also wanted to go away from even annual elections. This was a big deal to do that in that sense. Why'd they do that? When they looked at the behavior of legislators who were placed on such a short leash by the public, just 6 months in office or just 1 year, and at the mercy of being unseated after such a short tenure, the federal convention delegates saw all sorts of evidence of bad governance. For instance, legislators being willing to print more money in response to public clamor, saying, I wish the money supply was easier, and the legislature would give in. Or state legislature passing other laws that appealed to the public's short-term preferences but wasn't in their long-term interest. So the federal convention delegates were very intent on allowing members of the U.S. House to serve 2-year terms to enable them to get the long-term perspective when legislating and to act responsibly rather than responsively. And of course, they gave the senators 6-year terms. Similarly, similar kind of cautionary tale from states, federal convention delegates turned away from term limits of the sort that Pennsylvania had in its constitution. This was seen by federal convention delegates as unhelpful The whole point is we want legislators to gain the experience that's necessary for a good governance. So you don't see any term limits in the federal Constitution of that kind. Nor, I should be clear, were the one-house legislatures in Pennsylvania, Vermont, and Georgia seen as positive examples. They just simply weren't seen as providing the requisite amount of deliberation in lawmaking of the kind that was required. My main point, to sum up this kind of second portion of my remarks, is federal convention delegates benefited greatly from the experience of state constitution making that preceded it. Now, you might have gotten a sense here, and rightly so, that maybe there were some patterns in which states the federal convention delegates drew from, with Pennsylvania and Rhode Island being some of the kind of negative examples in a lot of these matters, and say Massachusetts and New York being more likely positive examples. But the point is that the federal convention delegates drew on a wide range of examples, from Maryland to others. Let me turn finally to subsequent years, what comes after 1787. By setting out the main ways that state constitutions influence the drafting of the federal Constitution, I don't in any way mean to suggest that this was the only purpose of state constitutions, to serve as a staging ground or a testing ground after which we get the federal Constitution. Nor, and this gets to my kind of third and final main point today, nor do I wish to suggest that state constitutional experimentation came to an end in 1787. And once you have the federal Constitution, everybody says, okay, well, that's the be-all, the end-all, where we want to be, and let that becomes the model. No, to the contrary. State constitutional experimentation has continued with great vitality for long after 1787. Really, what we have here is state constitutional experimentation and innovation has continued on a bit of a separate track from the U.S. Constitution. I would go so far as to argue, I have argued in books and writings, I'll argue here as well, I would say to a great extent we have two different approaches to constitutionalism within the U.S. political tradition. One is at the federal level, and the other is at the state level, allowing for a lot of variation among the states. One thing I'd encourage everyone to do, maybe everyone already has done this here. I know everybody got a copy of the Declaration, and part of that is going out. I would, for anybody who hasn't just taken a look at a state constitution, maybe take a look at a few state constitutions, I'd encourage you to do so. Maybe you've had a chance to look at the Texas Constitution already, because I know that's part of Texas education, but you haven't had a chance to look at another constitution to compare Texas with in that sense. I'd encourage you to do so. If you haven't looked at the Texas Constitution, definitely pick that up. Give yourself a good amount of time to kind of spend on that, because it's not a short read. We'll get to that in a minute. But do that, because the state constitutions, what you're going to find, if you look at these state constitutions and grapple with them, you're going to find a lot of provisions that just don't have any counterpart in the U.S. Constitution. So we're so used to looking at the U.S. Constitution, you're going to kind of look at some of the state constitutions, it's like, I see these different rights, I see all these limitations on government, I see kind of a greater role for the public playing a direct role. So let me turn to some of these distinctive tracks that states have followed even well after 1787. Let me focus on rights. You've had a lot of rights that have been added to state constitutions over time, and they've come in several groups. In some cases, you've had rights added to state constitutions where people just across America have said, we have an evolving understanding of this right. We'd love to actually put it in the U.S. Bill of Rights. We'd love to add it there. But the U.S. Constitution is so difficult to amend. It's such a rigid amendment process that people are foiled in their efforts to add a right to the U.S. Bill of Rights and say, at least we can put it in our state bills of rights. At least we can protect it that way. Let me just give a few examples. Half of the states have adopted equal rights amendments explicitly barring sex discrimination. Texas was one of the ones to do so in 1972, in just the year that the federal Equal Rights Amendment was being passed through Congress. Or, to give another example, well over half the states, really about 2/3 of the states now, have explicitly protected the rights of crime victims in their state bills of rights. There's been efforts to add a victim's Bill of Rights to the U.S. Bill of Rights, but it's failed so far. So those are some examples of the kinds of things you'd find in the Texas Bill of Rights, find in other Bill of Rights. Sometimes there's just been other general understandings of how rights can be, should be protected. Let me give two recent examples. I'm going to focus just on Texas, and both of these are unique to Texas. These other examples I gave were kind of Texas and other states. 5 years ago, really during COVID, shortly after the first burst of COVID, Texas added a right provision to its constitution, which explicitly states no state or local government official can ever close or limit religious services. This, of course, was in reaction to the idea that this had been done during COVID. 2021, this was passed and added to the Texas Constitution. No, never again, not even in a pandemic. They said we want to ensure that that's protected in a Texas Constitution. Or some of you may have voted in the November election just a few months ago in that sense in Texas. Some of you may have seen there were 17 constitutional amendments on the ballot. There's only been 27 amendments to the U.S. Constitution. Texas just added 17 amendments to its Constitution in 1 year. I want to highlight one of those in particular. A parental rights provision affirming parents' right to make decisions concerning their children's upbringing. There's no counterpart to this, not only in the U.S. Constitution, but in any other state constitution. That's unique to Texas. Now, I focused on provisions that you'd find in the Texas Constitution. How about if we look outside Texas? What are some of the other things we find? You would find 10 states that have constitutional provisions explicitly protecting abortion rights. All of these have been added in the last 3 years. Not in Texas, but in 10 other states. Or a handful of states have actually added explicit protection for the right to a clean and healthy environment. New York was the most recent to do so 3 years ago. That is found in the New York Constitution guaranteeing that right. So these are just some of the many recent examples of rights provisions that you'll find in state constitutions. You're not going to find in the federal Constitution. How about, it's not just rights though, state constitutions also contain a lot of restrictions on governmental power. And here the idea is, again, if you do look at the Texas Constitution, it's 90,000 words long. You might say, 90,000 words, how many words, what does that amount to? Here's one way to put it. The U.S. Constitution, including the amendments, is 7,500 words long. It means the Texas Constitution is about 12 times as long. People say, what's in there? Now, I should take Texas as one of the longer state constitutions. It's not as long as Alabama, which is nearing 400,000 words, but it's long. It's on the long side. One of the things you say, what's making up all those words in there? A lot of it is limitations on what government can do. As people over time have they've seen their legislators or the public officials do things, and they say, I don't think you're doing this responsibly. I'm going to limit you. A lot of provisions limiting the ability to borrow money, to go into debt, limiting the ability to raise certain taxes, limiting the ability to invest in private corporations of various kinds, and limiting the ability to authorize gambling or gambling operations. You will find all these in the Texas Constitution. And that's, again, as of the 90,000 words, a lot of those are going to be limitations of that kind in that sense. And again, the reason for this is the people of Texas, like so many other states, have said, we want to prevent the legislature from borrowing too much money. We want to prevent the legislature from raising taxes that we don't approve of. And they've just put those into the document. And then one final way that state constitutions have developed distinctively through the years that differs from the U.S. Constitution is by giving the people a direct role in electing a number of officials and in some cases making policy directly. State constitutions make a wide variety of state officials subject to popular election. For instance, many offices that are appointed by the president at the national level are elected at the state level. Just consider Texas in that way, where we directly elect the Attorney General, directly elect the Agriculture Commissioner, directly elect Railroad Commissioners. Other states hold elections for Insurance Commissioner or Treasurer. And then 3/4 of the states subject their judges to popular election of some kind, and here Texas would be one of those states. Partisan elections, as in Texas, nonpartisan elections in some states, retention elections in some states. Why have state constitution makers opted to make so many of these offices directly elected? Because their belief is that it's the best way to hold these officials directly accountable to the public. Now, that's a debatable proposition. Some people actually might say, I know that's the intent to make them more accountable. I'm not sure you've achieved that goal, but that's the logic here. Is if we're going to make these officials fully accountable to the public, they have to be elected by the public. That's the state logic of the approach. It dates back to the 1830s and 1840s, the Jacksonian era. And then about half of the states, again, not including Texas in this case, have gone so far as to say, we want the people to be able to initiate and vote on legislation directly, what we call direct democracy, voter-initiated initiative processes. There's no opportunity under the U.S. Constitution for the people to vote directly on policies, no opportunity in Texas, but half of the states provide that opportunity for the people to simply put a measure on the ballot and vote on it in the belief that that gives the people ultimate control. Well, my overall point to wrap up this third and final section of the talk is that state constitution makers have not been content, not at all, to simply follow the federal constitution in what rights they include, what governing principles they put in their document, and what the role of the people is. They have felt very free to add to or depart from the decisions made by federal constitution makers. And this is what leads me to conclude, as I really do conclude, that we really have two different approaches to constitutionalism in the U.S., a federal approach and a state approach. We're so familiar with the federal approach. We all study that. We all have a sense of that. That's what a constitution looks like. We come to think of that's the only approach. That's what a constitution needs to look like and act like. But I'd argue the state approach is very important as well. Preceded the U.S. Constitution, shaped that document, and continue to be an important forum for experimenting with and innovating about constitutionalism. And so in this year, 2026, yes, we're marking the 250th anniversary of the Declaration. We're also marking the 250th anniversary of the first constitutions in the U.S. and the first state constitutions. So, thank you very much.
So we have plenty of time for questions. I'm going to get the mic in.
Yeah.
Graduate students. After undergraduate students. Do we have undergraduate student questions? Let me start by, I indicated in the introduction that this variation, innovation, and experimentation was Jeffersonian in nature. You talked about this a little bit yesterday with the class, but there are many people here who worked in the class, so maybe you could elaborate on this difference between a state Jeffersonian tradition and a Madisonian federal tradition.
Thank you for that opportunity. So Madison and Jefferson had these debates about governance throughout their time, and they would have differences on all kinds of things, and they would discuss their differences. And one of the most notable differences was over how one should treat a constitution. Jefferson had a particular view. Jefferson said, really, each generation, which he counted as 19 to 20 years, Jefferson was always very scientific about this. He said each generation replaces each 19 to 20 years. So really, a constitution should only remain in force, really, every 19 or 20 years until the next generation gets a chance. Do we want to continue living under this constitution, or do we want to change it? Do we want to give our allegiance to it? Again, in that sense. So for Jefferson, it was very healthy that people would constantly kind of review their constitution and see if it was working. He shared that with Madison. Madison certainly was aware of his views, and Madison had a very different view. Madison said, I don't think you're viewing a constitution in the way that a constitution should be viewed. A constitution is not something that you should be kind of calculating about, where someone you get out the accountant's kind of lens and say, it's doing pretty well in this respect, but it's a little subpar here. On balance, let's keep it or let's let it go. Madison says that's not the way to view a constitution. Madison's view is constitutions should be viewed with veneration. And they should have the veneration that is really important for governments to function. And veneration comes from age, and also comes from viewing it, as I say, not in a calculating way, but kind of a respect for the document that, okay, if it really needs to be changed, it really needs to be changed, but let's see if we get to that point. So this came to a head when they were designing the amendment process for the U.S. Constitution. Jefferson had his views on that. Madison had his views. one would have to say that the Madisonian views triumph there more than the Jeffersonian views. And again, the U.S. Constitution has only been amended 27 times, and a full 10 of those were the Bill of Rights. 2 of those were to enact prohibition and then repeal prohibition. So my point is not that many changes. So the Madisonian approach can be seen as very much characterizing how we treat the U.S. Constitution. And yet, Jefferson might not have prevailed in those debates with Madison about how to structure the U.S. constitutional revision process. He definitely prevailed at the state level, though. The states, every single state if the U.S. Constitution, one would put it this, the U.S. Constitution is amended, if we do the calculation, about once every decade over its 24-decade history in that sense. Each state constitution across the board is amended about once every year in that sense. So a very different approach and very different, not just the fact of how often it's amended, but also the way that it's amended. And I'll close the question and answer this way. Jefferson's views really live on in the following innovation. 14 states require that periodically the people be asked that question. Remember that I mentioned how Massachusetts said after 15 years the people should have a question, do you want to call a convention? Well, 14 states still do that, and they require the question of whether you want to call a constitutional convention be placed to the public. The most common interval for that to be done is 20 years, which is exactly what Jefferson said he thought would be a generation. And so Texas is not one of those states. Missouri is one of those states. I'm thinking of states that would be close by here, neighboring states or roughly neighboring states. So that's very much the Jeffersonian approach lives on very much through state constitutions.
In terms of interpreting the state constitutions, and especially all the amendments, how might one go about an interpretation process of original intent, given that, I mean, we know about the Constitutional Convention because of Madison's notes. Is there anything like that for the amendments in the state constitutions, or is that also like, if somebody happened to record the notes, fine, and if not, then...
So the book that Professor Gisha very helpfully displayed at the beginning, that was my intent to go through all the records of the state constitutional conventions that drafted the state constitutions. Because we all know of Madison's notes, or many of us know about Madison's notes of the debates of 1787, but there are similar journals and debates kept for the states as well. And so that was my effort to compile these. It's interesting. There's been 250 about state constitutional conventions. We've only had one, 1787 at the federal level. 250. About half of those, they kept the full debate records. The other half, they kept journals. And it's interesting to see people, as they're discussing, whether to pay for a stenographer to keep the debates. Some people said, no one's ever going to care what we're doing here. Don't pay that. Don't waste that money. Somebody says, oh, no, some people might care a lot. And so that's one of the things is we do have very careful records. In fact, after I already encouraged folks to look at the text of their state constitution, but folks who are really intrigued by that and say, I want to learn more, I would encourage you to look at the debates about the drafting of a state constitution. You could look at the Texas debates and see, as the delegates drafted, here's why we drafted this Bill of Rights in the same way. Let's give an example. The Texas Bill of Rights provision on the right to keep and bear arms says that you have the right to keep and bear arms for the defense of yourself and the state. I mean, that we see the text that seems to suggest a broader view of right to keep and bear arms that we have potentially at the federal level. We can go to the debates and actually find out why people use the language they do. So we're very rich. Are there some cases where we don't have access to that? True. When we have the amendments themselves, when a legislature passes an amendment and the people vote on it, it's tougher to go back and say, here's what the people were exactly saying when they were voting yes on that. And yet we also do have legislative drafting, and they say, here's why we're writing this text the way. So we have a lot of opportunities to do a similar thing to what we do in understanding the intent of the U.S. Constitution at the state constitutional level.
Associate Dean Williams, for the students here, if you're interested in this, the University of Houston and the Honors College are going to work together with Oxford University, where there's something called the Quill Project, and they have student researchers who are working on American state constitutional
what degree were those efforts, what was the discussion about establishing independence in any one of those states through the execution of creating a constitution?
Basically what happened here is the Continental Congress had basically, early on in 1776, said we actually encourage the states to begin drafting their own constitutions in that way. Now, it is true there's a division there. I hinted at this. The very first two, New Hampshire and South Carolina, just said, we're at war and we don't know how long this war is going to go. We just have to have a functioning body in here so that we can govern ourselves. And so that was the very first two, the New Hampshire and South Carolina. By the time we get to Virginia, though, and then we get to New Jersey, they are very clear that they regardless of how long the war goes, they fully are looking forward for them to be drafting a constitution that will be their governing charter. To what extent was that built in with the anticipation of the Declaration? In Virginia, it definitely was. They were anticipating that, and so it was kind of, as we're about to move to Declaration, let's have a governing document in place so that we have our foundational constitution. Certainly New Jersey as well. And then you have a number of states, Pennsylvania, Delaware, Maryland. They would come in the latter part of 1776. But those initial folks were the trailblazers. They're just kind of saying, we got to at least have a temporary document to kind of just to govern ourselves while we see what happens. Let me just make one pitch though about you. I mean, I'm so encouraged by the plan to actually look at the Texas Constitutional Convention debates. Again, we get so much from the Federal Convention debates of 1787. I would argue, and actually this is what first got me so interested in state constitution that I've been studying for several decades now. It was reading the debates of the Massachusetts Convention of 1820. Or the Virginia Constitutional Convention of 1829, 1830. James Madison is coming back in the Virginia Constitutional Convention of 1820, 1830, and there he is drafting a redrafting of the Virginia Constitution. And there's John Marshall in there as well, Supreme Court Chief Justice. There's several other ex-presidents. And in Massachusetts, we have a number of other kind of very figures. So the richness of these debates, so the fact that that University of Houston is going to be involved in kind of really looking at those Texas Convention debates, it's a project that I would highly encourage participation in.
Well, please join me in thanking Dr. Dinan.